Good morning, everyone. Welcome. Thanks for attending today's OSHA Recordkeeping webinar. My name is Steve Donovan. I'm the Director of Risk Management for Accent HR Solutions. With me today is Randy Clayton, who is a Safety and Health Consultant here at Accent. We also have Beth Folk from our office, who will be monitoring the webinar and helping with any logistics or IT issues if we should run into any. Beth will also facilitate a question and answer session at the end of the presentation. So just to cover a few housekeeping items before we get started, today's presentation is scheduled to be approximately 30 minutes long, followed by a 15-minute Q&A session for any questions that come up during the presentation. So total about 45 minutes today. We're recording this seminar or this webinar today, and you'll be receiving an email with a link to this if you want to review the information at a later time. We've also muted everyone's phone from our end, so you won't be able to verbally communicate with anyone, but we will be utilizing the chat function within the software. You can use the chat function by clicking on the little bubble. It's the second icon to the left of those green icons up there. With that, we ask you, if you do use the chat function, to click on the little @ symbol at the bottom where that opens up and direct all your chats directly to Randy Clayton. Otherwise, you'll be chatting with everybody who's on the presentation. So you may also want to move that chat screen over so you're not covering the presentation slides. Again, we'll cover those questions that are chatted to us at the end of the presentation, unless there's something really particularly that needs to be addressed immediately, then we can also answer those questions as well. So with all that said, I'll turn it over to Randy Clayton, and we'll begin our OSHA Record-Keeping webinar.
Thanks, Steve. Good morning, everyone. Pleasure to be with you this morning. You guys, after the call today, are going to be getting an email, and on that email there will be some links to some websites that I'm going to be referring to today during the presentation. So I won't have to keep re-explaining that. And not knowing who all is on the call, not knowing what your depth of knowledge is to OSHA and OSHA record keeping, I thought we'd just kind of do a little background and a little familiarization with OSHA and who they are. Who is OSHA and where they come from? You know, what authority do they have over you and your workplace? Back in 1970, Richard Nixon signed in the Williams-Steiger Act. It's often referred to as the OSHA Act. It allowed the Department of Labor and gave them the authority to develop the Occupational Health and Safety Administration, OSHA, to determine what safety looks like in the workplace. Their general duty clause says that puts the onus on employers to provide a safe and healthful work environment free from recognized hazards to their workers. In their standards, they lay out the rights and responsibilities for employers and employees. Like I said, they have the authority to determine what safety looks like in your workplace, and they, over different types of industries and different type of work environments, they have a code of federal regulations. If you look down here at the 29 CFR, general industry is 1910, and this would be, if this was a book, it would be about the size of a large city phone book with a lot of micro font in it, so there's a lot of rules and a lot of standards. We also have one for construction, maritime, people work on docks and near the water, agriculture, and then they have a standard on OSHA record keeping, which is 29 CFR 1904. That's our subject today. It's made up, this record keeping standard is made up of 46 parts. As you see on the right here, it's pretty small. And they've reserved about 11 of these, so there's probably going to be some changes in the future. They've just made some changes in the last couple of years. So let's just start with who's required to maintain OSHA injury and illness records. If you're an employer who has more than 10 employees, you're required to keep OSHA records of workplace injuries and illnesses. There is an exemption for certain low hazard industries where these are industries that their injury frequency is less than the national average, and so they're allowed not to keep OSHA records. That email that I mentioned, there would be a link to this site, to the Appendix A, that gives this list, and it's all based on your NAICS code. There's an exception to that exception, and that is if, let's say, you're not required to keep OSHA records, but you receive in the mail at the beginning of the year that's from the Bureau of Labor Statistics and they're going to send you a letter saying, regardless of whether you need to keep OSHA records normally, this year we're going to ask you to do that because at the end of the year we're going to ask you to complete a survey electronically on our website. And this is how OSHA collects data, injury and illness data, so that they can kind of focus and target their efforts towards eliminating these types of injuries. So let's talk about what are the basics of an OSHA recordable work-related injury. What makes it OSHA recordable? There's 5 different levels or categories of OSHA recordability for injuries. The first one would be a loss of consciousness. This typically happens when somebody is overheated. Sometimes maybe if they're poisoned or there's an air quality issue, they might lose consciousness. Treatment greater than first aid, and they have to have medical treatment, is the real definition of the starting definition of what's OSHA recordable. And I'll kind of go through a scenario here in a minute. But anything greater than first aid and medical treatment would be OSHA recordable injury. Another category would be restricted work or transfer to another job. In other words, the severity of the injury was bad enough to where the doctor says they can't do their normal work or do certain things in their job that they normally do, so they place a restriction on that employee. If the doctor says they can't work at all, they need to stay home to recuperate from their injury, then that is another category. And then the last category is fatalities, which we hope never happens to anyone here on this call. Let me go back to the treatment greater than first aid. I'll just use a scenario. Let's say Randy is working in your facility and I get something in my eye and I go to the sink or I go to the eye wash and I rinse it out and I get it out. I don't have any more problems, so that's just first aid, no problem. That's not OSHA recordable injury. But let's say I can't get it out and I go to the doctor and the doctor rinses it out, which is a first aid treatment. It's still just first aid and it's not OSHA recordable because he hasn't at that point done any medical treatment. But if they got to take a tool or a pair of pliers or whatever tools they use to pull it out of my eye, at that point they've treated me medically, and that would now become an OSHA recordable injury. And in the OSHA standard, there's a lot of rules. We could talk for probably an hour and a half just on this point right here. What's the work relatedness, and is it OSHA recordable or not, based on a lot of different scenarios, and there's a lot of rules about what's first aid and what's medical. Let's say I'm a driver. I have a DOT card, and I have to drive for my job, and that when the doctor took that out of my eye, he put a patch on my eye and said, you know what, you can't drive for 5 days. So now that puts me in another category of restricted work. If you don't provide me work that I can do that is not in that job category, or if the doctor says I can't work at all, then it goes into the days away from work. We typically call that lost time. Little decision tree here. If a case does not result from a work accident, then it's not recorded. If it results from a work accident and an exposure in the work environment, and it's a death or an illness, and usually in illness we're talking about an air quality issue or a hearing loss, then it has to be recorded. If it's an injury and it has medical treatment or loss of consciousness more than first aid, or there's a restriction given, or there's a transfer to another job, then the case has to be recorded. If it's just a first aid type injury, doesn't meet any of these criteria, then the case does not have to be recorded. So I went through that pretty quick, but I think it's pretty plain. One of the things we want to make sure, I'm going to defer to Steve to talk about this, we don't want to confuse OSHA recordability with compensability. A lot of times that's easily confused because they all kind of, when somebody gets injured and we have to start treating that, then there's some things that happen, and a lot of people a lot of time will think that because it's not compensable, it's not recordable. Steve, you want to talk to that?
Well, I'd just like to reiterate that, compensability through the work comp system is usually defined by the state laws for the jurisdiction that you're working in, and that's totally different than the recordability. So there will be times, and we go back to that eye example that Randy mentioned, if you have to send someone to the doctor to have them wash it out, that's going to be a compensable work comp injury. You're going to pay for that through your work comp insurance, but it may not be recordable from the same thing, and vice versa.
Okay, so what OSHA record keeping do I need to do if I have a work-related injury or illness? Let's talk about the forms that need to be filled out and completed, because OSHA does require certain documentation to be completed when somebody gets hurt at work. The first document we would have is the OSHA Injury and Illness Incident Report. Now, you can use the one that's on their website that's an actual OSHA document, that's what we call the Form 301, or if you have an injury report from your state office, from your state work comp office, or from your insurance company that asks the same information or has the same information that's equivalent to what's asked on this form, then you can use that form and you don't have to fill out the OSHA incident report. And it's going to basically ask you all the questions that pertain to the case as far as who, what, when, where, and why. Anytime somebody gets hurt, they have 7 days to put that, to fill out that piece of paper, and then they have to apply what's on there to the OSHA Form 300, and we call it the 300 log. And that has to be put on there within 7 days of the incident. That's an OSHA standard. Basically, when you start this log, you're going to put in the year and the establishment name, the city and state, and then your first injury or illness is going to be marked in this first column over here where it says case number, and you can assign it whatever case number you like, the employee's name, their job title, the date of the injury, where did the event occur, what part of the facility, and then this brief description of what happened. The person was lifting boxes, lowering, they were driving, they were turning, they were twisting, whatever is on that injury report we want to list in this column, in this cell right here. Then this next box over here, this is how we classify the cases, okay? If there was a fatality, which we hope nobody would ever have to fill out this column, you'd want to check that box there. If it's days away from work where either we didn't accommodate a restriction or the doctor put the person off work, we would check that box. And if there was a job restriction, we would check the job restriction box. Any other OSHA recordable, for example, just an injury that didn't have a restriction or lost time, but it did have medical treatment, would go in this category in this column right here. For days away from work, we have to count days. OSHA has a lot of rules about how you count those days, when to start the days, when to stop, and we would list the number of days in that category of lost time in that column, and then job restriction. And there may be times when you have both. They may be job restricted for a while, and at some point they lose time from work, and then they come back to work. So we would list those days in each column. However, over what case it would be, we would pick the highest severity case if they have both. The last section here is just what kind of injury illness was it. Was it an injury, or was it what they call an illness? Would be like skin disorder, poisoning, loss of hearing loss, that type of thing. You have to update your 300 log as circumstances change. So when, let's say, somebody, you won't know how many lost time days there are until they come back from work, or come back from their lost time. So when they come back from lost time is when you need to update the log. There's a cap of 180 days on the log, and there is, when you count the days, it's calendar days. So it's not, if somebody gets injured on a Wednesday and he goes to the doctor and the doctor says you can't work, so starting Thursday we start counting the days, and then they go back to the doctor the following Tuesday and they say you can go back to work tomorrow. So Wednesday they go back to work. So the counting stops on that Tuesday, the day the doctor released them. And that would count days Saturday and Sunday as well, because they were available to work, not whether you had them scheduled or not. I hope that's not too confusing, but you just count straightaways. It makes it pretty easy to count the days. At the end of the year, you're going to total up all the columns on your OSHA log, and we're going to transfer those totals to OSHA 300A form. This is an important form because this is what OSHA looks for when they come to visit you, if they ever should, to determine whether you're doing OSHA record keeping and to make sure you're doing it correctly. So this is a summary of that OSHA log. So at the end of the year, beginning in January of the next year, you're going to fill out the form with 2017, the name of the company, address, etc., and then the NAICS code. The NAICS code is North American Industrial Classification System. It identifies what kind of work you do, what industry you're in, and that they use that for their trying to determine injuries by industry and by code classification. We're going to put the total number of deaths, if there are any, in that box right there, total number of cases with days away from work, or lost time, and then the corresponding number of days that we totaled up. Any job restriction injuries, we'll total up those and put the days right there, and then the other OSHA recordable cases will be put in that box right there. Sometime in that month in January, the company executive needs to put in the average number of employees and the total hours worked at your facility there, and you can get that from your payroll provider, and you want to fill that out. And the reason why they want to know the total number of hours is they're going to use this number here to determine a frequency. Basically, it's how many injuries in whatever class it is times 200,000 hours, or how many injuries per 200,000 hours, so they can compare companies, little companies to big companies. The top-ranking executive at the facility needs to sign and put their title and phone number and date on here. And then February 1st, you need to post this. You're only going to post the 300A and not the log, but it has to be posted in a conspicuous area, someplace where all your employees can see it, and it needs to remain up there until April 30th. It's really important you don't post the OSHA log because it does have private health care information on there, and we don't want to share that with anybody, so that needs to remain locked up in a file. But February 1st, you need to post that. Then April 30th, you need to take it down and put it in a folder somewhere that says 2017 OSHA Records, and you hang on to that. Because there is a retention period that OSHA requires you to keep these records. You must keep the previous 5 years of your injury and illness records plus the current year. If OSHA knocks on your door and walks into your business, and usually one of the first things they're asked for is your OSHA records, you have 4 hours to produce these documents. So it's important that you keep them current and you keep them accurately. So what we've learned so far about OSHA records is we have to fill out the 301 form, or your injury illness incident report, within 7 working days of the incident. You have to record it on the OSHA log within 7 days and update the log as circumstances change. And then in January, you have to complete the OSHA 300A summary using data from that log and post that February 1st, and we're going to take it down April 30th. A lot of my clients I walk into, they keep it up all year long, and there's not a problem with doing that other than the fact that it's easy to get lost, and you don't want to be able to keep track of it and keep that organized. So what's new in OSHA record keeping? In 2015, January 2015, OSHA made a rule that didn't become final until late 2016, when they have to electronically submit OSHA injury illness records into the OSHA website. And there's some criteria, and it determines who has to do that. There's a picture of what that OSHA website looks like, that page. In this top right-hand corner, there's a little launch button where you would go and develop or make an account or build an account for that establishment where you can start inputting the data from the OSHA 300A. So let's talk about who, what, when, and where, who has to file and what information needs to be input into the system, and then when it has to be input by. So the who is any establishment that has 250 or more employees, or establishments with 20 to 249 employees that meet a certain requirement of a particular type of injury. For establishments with 20 to 249 employees and whose industry NAICS codes are listed on the OSHA website, they have to do this inputting into the system at some point. Here's a list, and it's certainly not a complete list. Again, you'll get this on the email that has a link to this list right here, so you know whether or not you have to do this electronically if you fit into that 20 to 249 employee category. What information needs to be uploaded is the data from your 300A summary form. In the initial rule, it said that establishments with 250 or more employees are going to have to put in real-time data from their OSHA 300 injury forms and their 300 logs, and that OSHA's been sued. It's been heard, and now they're currently reconsidering the requirement for that real-time reporting. There's some real issues. The purpose that the director of OSHA at that time stated was to try to nudge employers to be more compliant if we make your information public. The problem with that is that public information, people can use without any context to what all those numbers really mean and any specifics to the requirement. So I think the current administration is looking to see if this is really something that we want to do. So I think at some point we'll see there's supposed to be a ruling later this year, and whether they're going to delete it and can take this off or make some sort of a change. So there'll be an update to that this year. The information has to be put into the system. Your 2017 information has to be input by July 1st of 2018. And then in beginning 2019 and years after that, subsequent years, the information has to be submitted by March 2nd. There's been a record-keeping change, and that has to do with the reporting of injuries. So far we've talked about recording injuries and illnesses. Now we're talking about reporting injuries, serious cases. So what is a serious case? A serious case is listed in the OSHA website as either a fatality, a hospitalization, amputation, or loss of an eye. And we'll just talk a little bit about those. This is a side-by-side of what the old reporting requirement was compared to the new recording requirement. A fatality has to be called in, a workplace fatality has to be called into OSHA within 8 hours. That hasn't changed. That's the same requirement stands. There is an exception to the fatality piece, and that's if one of your employees, this happens where they're in a motor vehicle and it happens out on the highway and they're killed, that does not require a call to OSHA or a self-report, unless that fatality happens in a car in a construction zone. A catastrophe, OSHA defined as where you put 3 of your employees in the hospital, and by putting in the hospital, we're talking about they were admitted and treated in the hospital as an inpatient. Once you were notified and you knew that was the case, you had 24 hours to call OSHA. They've changed that last year into just one person hospitalized. And this and the amputation and the loss of an eye additions that have been made have really increased the number of cases that are being reported to OSHA. And frankly, they really couldn't handle, they couldn't go investigate every single call that was made on all these. They knew that there were a lot of amputations happening out there that they weren't aware of, but they knew it was happening. So now, if you have to report to OSHA, there is a website that you can go to on their website where you can either put it into a form on the OSHA website or call it in. You want to make every effort to try to get a hold of them in this time frame. And it's once you're notified and you're aware of these things happening, it's important that we meet this deadline. They're going to ask you a list of about 25 questions when you call it in, and based on your answers, they're trying to do a little triage to determine whether they need to come out and inspect or they're going to let you do your own inspection. We've had a few clients where they've had some employees injured that required a hospitalization. And once they found out that they were going to be admitted and cared for and treated in the hospital, then we had to make that call. Just know that when you do that, it's like an invitation asking OSHA to come to your business and take a look around. And they see what they see, and if they see violations to their standards that we talked about at the beginning of the call, then those things can be cited, even if don't have anything to do with the injury itself. So it's important to have a good safety and health program, good safety culture, and that you're compliant with OSHA standards. So we just really hope that you never have to make that call. In my time as a safety and health consultant and a professional, I've had to investigate 5 fatalities. It's not a good thing for anybody. We hope that you never have to make that call. So as Steve said, we're going to take some questions. Beth, do you have any popped up?
Yeah, hi Randy. Yes, we have a couple questions. The first one is on the reporting. You mentioned that the loss of eye. Does that count also if you lose vision?
No, that's a good question. It's not a loss of vision. It's if you have damage, you lose part of your eye, or your eye comes out within 24 hours of an injury, then that has to be called in. You could lose your eyesight, you could have your eyes poked, or have some chemical or something get in your eye and you lose your vision, but that does not have to be self-reported.
Okay. We have another question. Again, on the reporting, what if you just go to the ER? Is that count as being hospitalized?
Nope. An ER visit, thousands of ER visits are made from workplace injuries every year. Does not require a self-report. It's after they've been admitted. We had one case where they were admitted and kept overnight that still didn't require a call because at that point they really hadn't determined what the treatment was going to be. But once they decided they're going to do surgery on this person and keep them in the hospital, at that point our client had to make the call to OSHA.
Okay, great. Well, that covers the questions. I will kick it back to Steve to wrap this up.
All right. Well, again, thanks everyone for attending today's webinar. I know OSHA record keeping can be confusing and many times frustrating for a lot of people, but that's just one of the many safety compliance services that Access HR provides, that our risk management department provides for our clients. So if you're a small to mid-sized business and you're facing challenges in the areas of risk management, payroll, human resources, and employee benefits, we'd love to talk to you about how ACSET can help you and your organization meet those challenges. So just give us a call or shoot us an email or visit our website. We'd love to talk to you. So with that, I'll just reiterate that you will be receiving an email with some of the information that was covered in the presentation, and I appreciate everybody's time today. Thanks, and have a safe day.